everyone. Welcome to this session of PYQs discussion. Dear aspirants, in this session we are going to discuss about the polity section of previous year 2018. Right now, in 2018 there were 10 questions from polity section. Right, and if you compare the 2018 from 2017, right, there was a drastic reduction in the number of polity section. Right, so in 2017 there were exactly 22 questions, but suddenly in 2018, right, there were 10 questions. So if you analyze the PYQs of prelims, right, you will find that every year, right, on an average range of questions from polity section is this 10 to 12. This is minimum range, right? Some year it has gone up to 18, or for example in 2017 there were 22 questions, but on an average, this is on an average number of polity questions in prelims section, right? GS paper 1. Now let's see the first question. See, this is a conceptual question, right? If you have conceptual clarity, then you can answer. Otherwise, all these options are confusing, right? So it says, which one of the following reflects the most appropriate relationship, right, between law and liberty? So what is the most appropriate relationship between law and liberty? Clear? Right? So first option, it says, option A, if there are more laws, there is less liberty. No, this is incorrect statement. Why? It is not sure that if there are more laws, it will reduce liberty or it will lead to less liberty. Right? In fact, if there are laws, right, more laws, right, there would be liberty. But there is no chance that there are more laws and it will lead to less liberty. Clear? Second option, option B, it says, if there are no laws, there is no liberty. Yes, no laws, no liberty. Why? Because see, for example, Article 19, it talks about different types of freedoms, right? And when we talk about liberty, right, liberty does not mean license to do anything or absolute liberty. There are reasonable restrictions, right? For example, Article 19, clause 2, clause 6 imposes a reasonable restriction. So this statement, option B, it says, if there are no laws, there is no liberty, obviously, and especially weaker section, right? If there is absence of law, obviously the powerful one will dominate the weaker section. That's why law is must, right? And this statement is correct, that if there are no laws, there is no liberty, especially for weaker section. There would be arbitrariness, right? Atrocities of stronger over weaker, right? So option B is the right answer. But read other options. She says, if there is liberty, law have to be made by the people. See, though we can see that the laws are made by the people, but people do not make law directly, especially in context of democratic country like India, right? People elect their representatives, and or we call them legislators, right? And on behalf of the people, the legislators, the members of parliament or state legislatures, right, makes law. So people do not make law, right? Their representatives make law. So this statement is also incorrect. Last statement, if laws are changed too often, liberty is in danger. No, right? Though law should be stable, but it demands modification over the period of time, right? For example, even the constitution, right, it is called transformative document. Over the period of time, it has been amended several times, right? So law shouldn't be static, it should be modified as per the changing demands of the society. Clear? So B is the right answer. If there are no laws, there is no liberty. Clear? Now second, again very important question. It says, if the President of India exercises his power as provided under Article 356, yes, very important topic, President's rule. right? President governor relationship, right? Center state relationship. These topics are UPSC's favorite topic. Clear? So uh, article 356 of the constitution of a particular state, then clear. So when president of India exercises his power under article 356, it simply asks that when president rule is imposed in any state, right, what are the power or what is the power exercised by the president of India? So first option says the assembly of state is automatically dissolved. No, right? Even though the president rule is imposed under article 356, the state legislature or the assembly of state is not automatically dissolved. It may be suspended, right, but not automatically dissolved, right? Or it may be dissolved later but not automatically suspended, dissolved, right? Second statement, the power of legislatures of that state shall be exercisable by or under the authority of parliament. Yes, when state means when article 356 is imposed in any state, the state legislature is suspended, right? And the power of that state legislature is exercised by the parliament of India, right? Means, for example, there is a state, just an example, Goa, right? Or take any example, and if there is or article 356 is imposed, right, then what will happen, that after imposition of article 356, the legislative assembly of Goa will be suspended and the powers of legislative assembly of Goa will be exercised by the parliament of India, right? So this is the correct statement, but read the other options too, as I said every time. So article 19 is suspended in that state. No, article 9, there is no impact on article 19 after imposition of article 356. It is suspended only when national emergency is declared under article 352, right? Article 356 does not impact article 19, or article 19 is not suspended when article 356 is imposed in the state. It is suspended only when there is national emergency under article 352. Last statement, the president can make laws relating to that state. No, as I said, as we have seen, that parliament makes law on behalf of state legislature, and if the parliament is not in session, only then the president can promulgate ordinance under article 123. Clear? So B is the correct answer. Next, with reference to the elections of the president of India, right? Consider the following statements. First statement, the value of vote of each MLA vary from state to state. Obviously, this is correct statement. Why? Because the number of MLAs in each and every state is different, right? For example, a state like UP, right, has very high number of MLAs. A state like Goa, a smaller state, as comparison to UP, it is very less, right? So obviously, when the number of MLAs are higher, obviously their value of vote will vary from state to state. A smaller state, less value. Bigger states like UP will have more value. So first statement is correct. Second statement, the value of vote of MPs of Lok Sabha is more than the value of votes of MPs of Rajya Sabha. No, the value of votes of MP of Lok Sabha and Rajya Sabha are combinedly calculated, right? And their value is equal, not different. So second statement is incorrect, right? I will show you the formula. So just remember, only first statement is correct. So option A is the right answer, only one, right? Here's the formula. You can see this is the value of vote of MLAs, right? State population divided by 1000 divided by number of elected MLAs, right? And one more important thing I would like to tell you, that you should remember that only elected MLAs and MPs, elected MLAs of state legislative assembly or legislative assembly of UTs like Delhi and Puducherry, and elected MPs of Lok Sabha and Rajya Sabha, no nominated member of state legislature or union legislature, that is parliament, participate in the election of president. Again, I am repeating, only elected members of state legislature, state legislative assembly, that is, and elected members of parliament, that is Lok Sabha and Rajya Sabha, participate in the election of president. Clear? So that is the value of vote of MLAs. And as I said earlier, that bigger states will have more value, smaller state will have less value. Again, value of vote of MPs, right? And what is the formula? Total value of votes of MLA of all that states, that is calculated using this formula, divided by total number of elected MPs of Lok Sabha plus Rajya Sabha. So the number is what, or the value of total elected MPs of Lok Sabha and Rajya Sabha is calculated together, not differently, right? In that sense, only first statement is correct, second statement is incorrect. Now, next question. Consider the following statements. In the first Lok Sabha, the single largest party in the opposition was Swatantra Party. Right? No. Actually, in the first Lok Sabha, right, in that remained between 1952 to 1957. So, in the first Lok Sabha, Communist Party of India, CPI, right, was the single largest opposition party, right, and it had 16 MPs. Clear? And as it says Swatantra Party, it was founded in 1959, much later, right? By whom? C. Rajagopalachari. In that sense, first statement is incorrect. Clear? Second statement. In the Lok Sabha, a leader of opposition was recognized for the first time in 1969. Yes, this is correct. Though opposition existed even from the first Lok Sabha, but it was the fourth Lok Sabha, right? Fourth Lok Sabha. During that time, for the first time, the leader, means the post of leader of opposition, was recognized for the first time. Which year? 1969. Clear? Next, third statement. In the Lok Sabha, if a party does not have a minimum 75 members, its leader cannot be recognized as a leader of opposition. Again, wrong statement. Why? Because the criteria is that the single largest opposition party must have at least 10% of total seats of Lok Sabha. And what is the total number of seats of Lok Sabha currently? 543, right? And 10% of 543 is 54.3, or approximately you can say 55. So it should be 55, right? 55, not 75. So again, third statement is also incorrect. So only second statement is correct. Go for option B. Clear? Next, fifth, though statement is longer, right? Time taking question. It says, with reference to the Parliament of India, which of the following parliamentary committees scrutinize and report to the House whether the powers to make regulations, rules, sub-rules, bylaws, etc. conferred by the Constitution or delegated by the Parliament are being properly exercised by the executive within the scope of such delegation. Clear? So simply it asks that which parliamentary committee, right, scrutinize and report to the House whether to power to make regulations, rules, sub-rules, bylaws, etc. Right? So if you know, then you can easily answer, and if you don't know, then you can apply your logic. Right? It asks about power to make regulations, rules, sub-rules, bylaws, etc. Now let's see. Committee on Government Assurance. No. Committee on Subordinate Legislation. Right? Legislation means what? Law. Making. Process of making law. Right? Both. Rules Committee. Though rules are also included. So there is confusion between B and C. D, Business Advisory Committee. No. There is confusion between option B and C. So go for option B. Committee on Subordinate Legislation. It has function to what? Scrutinize and report on the powers to make regulations, rules, sub-rules, bylaw, etc. right? So B is the right answer. Go, here is the explanation, you can read. So this committee on subordinate legislation, it was constituted in 1953. Clear? And the key functions of this committee is this, we have already discussed, right? Just have a quick look. Other committees, committee on government assurance, right? It examines assurance, promises and undertaking given by ministers on the floor of a house. Rules committee recommends amendment to the rules of procedure and conduct of business of the house. And business advisory committee recommends allocation of time for various items of business agenda in the house. So options are also important, right? It is possibility, right? Or that in upcoming prelims question may be from the options, right? Next, again important question, and I would say that it is a factual question. If you know about the money bill, you can easily answer. It says, regarding money bill, which one of the following statements is not correct? Right? Not correct. First, a bill shall be deemed to be a money bill if it contains only provisions relating to imposition, abolition, remission, alteration or regulation of any tax. Yes, this is the correct statement. It is one of the first criteria of a money bill. Clear? Second, a money bill has provisions for the custody of the consolidated fund of India or the contingency fund of India. Yes, this is also correct. Clear? Third, a money bill is concerned with the appropriation of money out of the contingency fund of India. Appropriation of money out of contingency fund of India. This statement is tricky and this statement is altered. Right? It is incorrect. Right? And it is not contingency fund of India, but it is consolidated fund of India. Right? Means a money bill is concerned with the appropriation of money out of consolidated fund of India, not contingency fund of India. Right? So this statement is incorrect. And as this question asks which of the following is not correct, so option C is the right answer. Read other option. D option D also. It says a money bill deals with the regulation of borrowing of money or giving of any guarantee by the government of India. Yes, this is also right, one of the key feature of money bill. So all these three statements are correct, but option C is not correct, and the question demands not correct statement. Clear? So option C is the right answer. Next, consider the following statements. It says, the Speaker of the Legislative Assembly shall vacate his or her office if he or she ceases to be a member of the Assembly. Yes, once a member of Legislative Assembly, right, who is a Speaker, right, who is also a Speaker, if he or she ceases to his membership of the Assembly by way of any reason, whatever, right, he has resigned or she has resigned, she has been what, or under the charge of anti-defection law, right, that person has been, or that member has been ousted, then that person will, means the Speaker will lose or vacate his or her office. This is correct. Clear? Second statement, whenever the Legislative Assembly is dissolved, the Speaker shall vacate his or her office immediately. No. Though House is dissolved, Assembly is dissolved, right, but the Speaker shall remain in the office till the first meeting of the newly elected Assembly. Right? Again I am repeating, even though the House, means the Legislative Assembly, has been dissolved, in spite of that, the Speaker shall not vacate his or her office until the first meeting of the newly elected or the first meeting of the next Assembly. Right? So second statement is incorrect. Only first statement is correct. Go for option A. And where it is written? It is written under Article 179A. Right? So under Article 179A, Clause A, it says, a member holding office as a Speaker or Deputy Speaker of the Legislative Assembly of a state shall vacate his office if he ceases to be a member of the Assembly. Right? If the member, means if the Speaker or Deputy Speaker loses his seat, loses his membership, then he or she must vacate his or her office, whether speaker or deputy speaker of legislative assembly. Same is applicable with the speaker or deputy speaker of Lok Sabha, right? Second statement, whenever the legislative assembly is dissolved, the speaker shall vacate his or her office immediately. Not correct, as I said. Where it is written again under Article 179 Clause A, it says whenever the assembly is dissolved, the speaker shall not vacate his or his office until immediately before the first meeting of the assembly after the dissolution, right? Only the speaker shall or deputy speaker shall vacate his office when he or she has lost his membership by way of resignation or by way of defection or whatever. Now next question. So again important question. It says consider the following statements. First statement, the Parliament of India can place a particular law in the 9th schedule of the Constitution of India. Yes, right. And what is 9th schedule? It is related to land reforms, right, to reduce inequality in the society, and it was placed in the Constitution in 1951, right? Clear? And what was the main purpose? To reduce inequality in the society, and it is, as I said, related to land reforms. So first statement is correct. Second statement, the validity of law placed in the 9th schedule cannot be examined by any court, and no judgment can be made on it. See, this statement was correct till 2007. Why 2000 till 2007? Because in 2007 an important judgment of Supreme Court came, and the name of that judgment was IR Koilhu versus State of Tamil Nadu, right? In that case, Supreme Court held that any law that has been placed in Schedule 9, like, is subject to judicial review if it has been placed after 1973. That, and why 1973 was a benchmark? Because this year it was Keswanand Bharti case, right? So any law that has been placed in the 9th schedule, right, after Keswanand Bharti case is subject to judicial review, right? And it was propounded by the Supreme Court in IR Koilhu case 2007, right? So this statement is incorrect. Go for option A. Only first statement is correct. Next, which of the following are regarded as the main features of rule of law? So if you know the features of rule of law, you can easily, this concept was propounded by A.V. Dicey, very important personality, right? And if you have read Article 14, you can easily answer. So features of rule of law. First, limitation of powers. Yes, right? Supremacy of law. Clear? Equality before law. Yes, this is also the feature of rule of law. Third, people's responsibility to the government. No, this is not the feature of rule of law, right? It is the responsibility of the government to protect people, right? To protect its subject, right? Not it is the responsibility of people to the government. Liberty and civil rights, obviously, right? If there are no laws, we have seen in the first question, right? No law, no liberty. So there must be rule of law, and rule of law ensures liberty and civil rights, right? So all these three, first, second and fourth are correct. Go for option C. Clear? It is a simple question, I would say. Now last question, you can read the explanation here. Now last question of the day. Again, this is a easy question, and that year Puttaswamy judgment had come, and that's why this was in news and UPSC asked. So you must focus on current affairs also, right? So it says right to privacy is protected as an intrinsic part of right to life and personal liberty. Yes, right to privacy is a part of right to life and personal liberty under Article 21. It says, which of the following in the Constitution of India correctly and appropriately imply the above statement? So clearly it is under Article 21 and the freedom guaranteed in Part 3. Clear? So right to privacy is simply, you must know that it is part of Article 21. right to life and personal liberty. Under which judgment? Puttaswamy judgment, right? So Article 14, right to equality, right to Article 17, abolition of untouchability, right? Article 24 prohibits exploitation of children. Clear? So this was all about the PYQs of polity section of year 2018. We will continue this series in next lecture. Thank you for watching.